Good afternoon, sir. Good afternoon, sir. Sudhir, sir. Sir, we are not able to hear you. Your audio is on mute, sir.
Did it? Okay, now it's okay. Thank you.
Now it's
Yes.
Darwin.
Yes. There was some technical glitch. Sorry for delay.
No
That's
issue,
why I
sir.
was not responding to even
My
phone call.
call
Na?
also. Yes,
Yes.
sir. Yes, sir.
So actually, what happened that the file
Hmm.
I was trying to just rename, and
Hmm.
in that instance only it got you can say deleted. So my son was also not here, so he was out of town. So I just rang him, and with his help, was able to recover it.
You are able to do it. Okay,
Just
sir.
yeah, just now. I mean, everything happened after 2:50 only. Yes.
And we will wait for 2 more minutes and then we will start the technical session.
Okay.
Participants are joining.
So let me first see if I can share the slides. Na?
Yes, sir.
I should recheck in the
Darwin,
meanwhile.
make the sir also as the host.
Is it
Yeah.
visible now?
Yes,
Yes.
yes, yes.
Okay. I will just. But you said you will yourself copy and
Yeah, we will record.
send it
We
to.
will record
Ah,
from our side, sir.
okay. Okay.
Yes, we are able to view your slides also. Yes, perfectly.
Okay.
Okay, Kanmani, we can start.
Yes, ma'am, but the introductory speech will be delivered by Rajeshwari,
That
ma'am.
is Rajeshwari. Ask her to.
We have already wasted so much of time.
No issue,
Yeah.
sir. We will start, sir. We have
Okay.
enough time, sir.
Okay. Okay.
Yes, ma'am, shall I start?
Yes, yes, Rajeshwari. You can.
Okay, ma'am. So good afternoon. I am Rajeshwari, first year student from LLM, Department of Intellectual Property Law from School of Excellency in Law, Tamil Nadu Dr. Ambedkar Law University. So on behalf of our institution, we would give a warm welcome to the participant for attending today's session on patent law on the topic patenting in agriculture, academic and legal perspective. So before proceeding, would like to give some instructions to the participants. So participants are kindly requested to disable their video and mute the audio for uninterrupted flow. If any questions, it can be posted in the chat box, which would be discussed during Q&A session. Attendance will be given by our student coordinators and feedback form will be provided at end of the session. Now taking immense pleasure and honor, welcoming our resource speaker and keynote speaker, Dr. Sudhir Kochhar. Sir is specialized in plant breeding and trained in India and abroad in the field of generic resource, agrobiodiversity, intellectual property right, and agricultural management as various experience in ICAR, over 40 years in agricultural research, coordination, and policy perspective in plant breeding, plant generic resource, and IPR management. Dr. Kochhar has also made key backstop contribution of the amendment in the protection of plant variety and farmer right 1999, the Biodiversity Bill 2000 and the Patent Amendment Act 1999, 2002 and 2005. Sir headed the IPR unit in ICAR briefly in its foundation stage as Assistant Director General and was being member of NBA Committee on Agrobiodiversity as amicus curiae over 9 years. Once again, it's our immense pleasure to have you today, sir, to cultivate our knowledge. Over to you, sir. Thank you.
So thank you very much. First of all, let me profusely thank your HOD, Dr. Lucy, and also welcome all the students and participants to this lecture. This lecture is basically on patent law and policy and governance. So as far as my topic is concerned, I was thinking to just focus it on agriculture. So some of the things which are of common nature may also crop in this lecture, but basically it is about agriculture. So let us see some of the historical insights of industrial property rights in agriculture. And you know, this Paris Convention is common to all industrial property. And since it is lecture on patents, so in respect of patents, it is patents as well as utility models, means petty patents, small patents, and right of priority. That means if filing is done in one of the member states, it will be honored by all other member states as the date of first filing in any of these countries. Then this reigned over a long period of time, and this was purely about intellectual property, means being branded, and then looking into competition in the market, and also interpersonal relationships in the market, means company to company also, to handle all the matters related to intellectual property protection. Then in 1947, the General Agreement on Tariffs and Trades, and that came into surface, which determined trade-related aspects of industrial property. Of course, all other aspects also, but it also included industrial property. And in 1970, this Patent Cooperation Treaty provided a unified filing procedure for international applications. I mean, there is no international grant of patents, but there is international application, because it gives an insight to all the persons in the field to have an idea about that application upon its publication and upon its result of its examination during publication, also, etc., so that any licensing arrangements or other things, expression of interest, whatever has to be done, can be done at a multilateral platform. Then application to PCT application to seek protection of invention in designated contracting states. So you have to tell at the time of filing the PCT application that in which country you intend to apply for patent application separately later on, and then get separate patent depending upon the interest in trade in that country with respect to the product of patent. Then in 1989, that was the year when a very interesting development came in, means agriculture was also included into the trade-related industrial property for the first time. So agriculture and IPR were discussed along with the other general agreement on tariffs and trade. And this went on for 6 years of negotiations, and Marrakesh Agreement was signed in 1994. And based on that, in 1995, 1st January 1995, the World Trade Organization was established. And it has got a number of agreements in its fold, and these are package of agreements. It's not optional for the member countries to agree to one agreement and not agree to the other agreement, but as a package, all these agreements are agreed upon. This is the understanding. Then as a part of this package of trade, TRIPS agreement elaborated patents as a standard of IPR and further included plant variety protection vis-a-vis sui generis IPR as its subset. So we'll come to these things. Then as far as actual examples of patents, some of the early patents on industrial property which affected agriculture, which revolutionized agriculture. I mean, in the medieval era, if you know, in the medieval history, that there was a renaissance, the industrial revolution in Europe, and it's around that period only that all these inventions were made and got protected under patents. So in England, for example, this crude engine came, although it was not so successful, but it was a beginning. And then its improved version came in 1769 and further improved ones in 1782 and 1790, again in Scotland and England. And then in USA, a seed drill that was horse-drawn drill for sowing in rows that was invented in USA in 1701. Then in 1770, spinning jelly that to spin cotton thread was again invented in England in 1770, and all these are patents granted. Then cotton gin to separate fiber from the seed, and again it was invented in 1793, but actual notification came in 1807, maybe due to some technical resolves which were to be made, expected to be made by the inventor and to be accepted by the patent office. Then reaper to harvest the crops, it was invented in 1831, again in USA. This plow, that is self-polishing cast steel plow, also known as mold board plow, that was invented by John Deere. You know, these John Deere tractors are very popular here, green color tractors and all. So they claim that this first plow was invented by them. Of course, one first, you can say, industrially successful plow was this one, and then in 1837 a patent was taken on it. Another patent on barbed wire, even to fence the crops area. That was taken in 1873. In USA, there were a lot of, you can say, suits and countersuits against each other by different applicants for the patents for barbed wire. But then finally, the person who came out successful was Joseph Glidden, and it was in 1873. Then there's a package of patent on peanut agriculture science, which is for digging and cleaning of soil around this peanut. And you see this peanut butter is so popular now, it is entered Indian market also very lavishly. And in US, this was the one because everything related to agriculture. And this is very early age. I just wanted to give you some examples. I give you some more examples of plant patents under the US Plant Patent Act 1930. So this act was specifically designed to provide protection to plants, not to any industrial property or not as common utility patent, although it was a part of the statutes covered for the utility patents. But then a part of that, a few sections were separately given under which this act was, you can say, enacted by the Parliament of USA. I mean, you can say Congress, US Congress. And by now, 34,900 something, which is approximately as much as 35,000 plant patents have been issued. And these patents are affixed as PP. The utility patents in USA are affixed as US serial numbers, and the plant patents are affixed as PP, have been issued. And I have already told you that this enactment is attributed to very, you can say, hardworking horticulturist Luther Burbank, who is in his 55 years of career as horticulturist had come out with some 800 new varieties of different crops, trees, vines, and forage crops, cereals, etc. And when he died in 1926, then his heirs and even US professionals, they thought what will happen to the And this heritage which he has produced, and how this will be properly, officially, you can say, organized into a certain economic activity, so that there is an example is set and more Burbanks can be produced by the United States. And when this patent was, and for justification of all these things, testimonies of some renowned inventors and others, these are taken by the Congress. And Thomas Alva Edison was one of the persons who gave a testimony for this, who himself had got more than 1026 US patents to his name, and about 250 patents in different European countries to his name. And he was the one who gave this statement that if US Congress considers enacting this Plant Patent Act, then definitely our motherland can produce so many Luther Burbanks. And posthumously, Luther Burbank got 16 plant patents for the varieties contributed for him, of course, which were later on managed by his inheritors and successors, the companies and the persons in the family. Some major plant contributions of this person is about this Burbank potato. When there was an Irish famine due to a very obnoxious disease in Europe, this was the potato, russet Burbank potato, which did wonders because it was resistant to that disease. And later on, you can say this McDonald, they are using the same potato for their French fries and all, even till date. I mean, for more than 150 years, 180 years now. Then, and plums and prunes, breakfast prunes, apples, blackberries, raspberries, strawberries, fruiting cacti, cherries, figs, grapes, nectarines, peaches, pears, plumcotts, quinces, almond, chestnuts, walnut, grains, grasses, and other forage. If you see this particular area of California where his fields were located, it's very rich in horticultural crops. And he did wonders in bringing out new varieties for all these crops. Then there are still some more examples of US patents granted to plant varieties, just to tell that there can be patents from standard or utility patent system also. And in this case, of course, sometimes the claims are so wide that it will cover seed and also its method of propagation, and also some of the, you can say, uses, industrial processing uses of out of this, if it is a utility patent. But when it is a plant patent, it is related to only that variety. These names and numbers which you see on the screen, that will tell you how this naming has been done for, titles have been given to these patents. Another system of patent protection, of course, I mean, generally people will think that plant variety protection is not a part of this patents per se, but I will come to this in next slides to tell you, to confirm you that how it's a part of that. So it is 331,000 plus titles have been granted in the UPO member states. At present, more than 78 countries are already members of Union for Protection of New Varieties of Plants. And of course, out of these, some 187,000 plus titles have already ceased to be in force because of the term of protection is completed, or for some other minor reasons sometimes. And still, there are more than 155,000, that is 155,000 plus titles of protection in force in UPO member countries alone in plant varieties. Now I am giving examples of some of the landmark US biotech patents. The first one is process for producing biologically functional molecular chimeras or chimeras. This is about production of transgenics, because once callus has been produced, then later on it has to be developed into, differentiated and developed into a full-fledged plant. And for that, this process has been patented and by Stanford University in California in 1980. Then this famous, you can say, patent about this Chakravarti, about the oil-eating bacteria, because these microorganisms, they can degenerate the energy-generating plasmids from the bacteria, and this patent was granted by the US Supreme Court with a long division. I will come to that, I think 5-4, and so much opposition was also there that it should not be granted. But this was the one where they said that anything under the sun which is invention and qualifies for patenting can be patented, and that's where this patent was granted. Then, of course, whether it was worked or not is a separate story, and I'll not come to that so easily early. Then bioscience got one patent on DNA encoding insecticidal BT, cry1 BT proteins and recombinant. So this BT cotton case, this was the first patent on BT1, and from that, all this revolution in the cotton production and that thing came. Now, this is the explanation about the historic Diamond versus Chakravarti case in the US Supreme Court, that it was genetically engineered bacterium. Generic name is, genera is Pseudomonas, that had the capacity to break down crude oil, and also known as oil-eating bacteria. The inventor is Ananda Chakravarti. And there was an appeal for patentability issue, and the ruling was 5-4. And what the ruling said is that a GMO may qualify for patent protection as a new manufacture or composition. So then there was, in a counter argument, another case cited, the Funk brothers versus Kahlo inoculant. The court distinguished the accused plaintiff. Kahlo had created a mixture of naturally occurring bacteria, whereas Chakravarti had created a new bacterium with characteristics not found in nature. So it was in that context. In its opinion, the court expressed its conviction that Congress intended the patent laws to encompass under the sun made by man. So anything that is made by man under the sun, which has got the patentability qualification, so that can be granted patent, subject to all opposition and all other things. So the Kahlo Funk brothers versus Kahlo inoculant case was that the inoculant company Kahlo brought a patent infringement action against Funk brothers, and alleging that its patent on an inoculant for leguminous plants, that means pulses, etc., that is legumes, was being used by Funk brothers without authorization. Because you generally give some of the nitrogen fixing bacteria to that, and there can be combination of other nutrients also coming to a plant. The inoculant comprised of 6 bacteria species, each of which physically existed in nature. Kahlo had created the inoculum using specified strains that would not impede the efficacy of others in the mixture. Because after all, some R&D has to be done. Any product cannot go to market without any commitment and potential, you can say, reach to the end users for its benefits. But the court in the majority ruling still told that the combination of species produced no new bacteria, no change in the species of bacteria, and no enlargement of the range of their utility. And that's why the patent was invalidated. So that is where they try to argue their tell in their clarification that Anand Chakravarti's case was not similar to this case. Now in India, in 2003, one patent was upheld by the High Court Calcutta, and that was about the microorganisms. And you see, they say that microorganisms were not patented in India, or any products were not patented in India. But what was being done in pharmacy was that in the name of lyophilization, lyophilization means the bacteria, these got sedative, you can say, and their activity that comes as a numbness. But finally, what happens is that you can use is this product for the purpose of healthcare cure and fighting against this cough and cold, etc., and things like that. And this was a process for preparation of infectious bursitis vaccine, and it was for poultry, and that's why I am mentioning it in agriculture. So the patent application was as early as 1998. That was the transition age. India had signed the WTO agreement, but it was not enforced in India. It was enforced in India on 1/1/2005. I will tell you about that also. And invention involved live vaccine. The end product of the process resulted in living organism, and patent was refused. The point of dispute was whether a process for preparing this vaccine that has living or lyophilized virus in the end product can be patented or not. And petitioner's argument in the High Court was that he cited two patents. One was the process for reuterin, that is some other pharmaceutical patents, and process for theoretical preparation of reduction of acute diarrhea, both involving living organisms. And controller's argument was मम्मी से बात कर रहा हूँ, लेक्चर कर रहा हूँ इसका कमर से बात कर ली. Sorry. Controller's argument was that the end product in the patent is not living, because living organism was lyophilized, resulting in the death of the living organism. Hence, process were patentable. But court didn't agree that lyophilized organism will be dead organism. The contentions of the controller not justified, because lyophilization does not cause death of organism. So then the court further held that manner of manufacture should be construed to include living organisms. So it was a landmark judgment in the transition stage, where you can now say that even a product patent on microorganism was granted in India even prior to 1/1/2005, but of course with the intervention of the court. Now, after having seen all this historical perspective, let us see some standards set by TRIPS agreement for patents in agriculture. There are, of course, 8 sections, but 7 standards. The 8th one is the control of anti-competitive practices in contractual licensing, like anti-dumping, etc. And these 7 standards are copyright and related rights or neighboring rights, trademarks, geographical indications, industrial designs, patents, and of course, in patents, PVP or effective sui generis IPR have been obligated as the subset of patents. This is important. And then layout designs or topographies of the integrated circuits, protection of undisclosed information or trade secret. Now, part 2 of the TRIPS agreement deals with the standards concerning the availability of IPR, and section 5, section 5 deals with patents, and its article 27 on patentable subject matter say that patents shall be available for any inventions, products or processes in all fields of technology, including agriculture and biotechnology, provided that they are new, involve an inventive step, and are capable of industrial application. And of course, subject to provisions of paragraph 2 and 3 of this act, where some exceptions have been allowed. And what does this section 2 say, article 2 of the TRIPS agreement say, is that members may exclude from patentability inventions. I mean, may exclude doesn't mean that members have to exclude. So in some of the countries, some of the aspects related and even covering these things may be getting patented, but it is an optional exception. Then inventions, the prevention within their territory of commercial exploitation of which is necessary. So prevention then within their territory of commercial exploitation of which is necessary to protect public order or morality, including to protect human, animal or plant life or health, or to avoid serious prejudice to the environment. So under these 3 specific categories, exceptions can be given. So in context of public order, in context of morality, in context of human element, animal or plant health or life, and serious prejudices to the environment. In all these circumstances, if a member country chooses not to grant patents within their territory, they are free to do so. Then provided that such exclusion is not made merely because the exploitation is prohibited by their law. This is what they say, that you still are answerable to the TRIPS Council, that you have to tell us how you thought that it was considered necessary, and means if there is any issue of dispute settlement, suppose there is some imported patented technology which is to be exported by some member country and that raises an objection in the TRIPS Council, then this member has to defend. So that means it is not merely by the law, but then there is a justification that the commercial exploitation within their territory has to be prevented for as either of these reasons and either or all of these reasons, and that is why it has been not granted. I mean, it has been provided that such patents will not be granted in their territory. Now, in the TRIPS Article 27.3, there are 2 sub-articles, that is sub-articles. One is A and second is B. And A is members may also exclude from patentability diagnostic, therapeutic, and surgical methods for the treatment of farm animals, for the treatment of animals. And since we are dealing with agriculture today, so I have just added word farm animals, because it can be other animals also. Thus, veterinary methods may be excluded from patentability, but vaccines involving microbiological or biotechnological inventions may not be excluded. So this is just an implication. And what does this article 27.3b says is that members may also exclude from patentability plants and animals other than microorganisms. So that means where plant, they choose not to grant patents to plant and animals, they can do it, but they still have to give patents to microorganisms, of course, where it is qualifying and where it is permissible. This is important. And then also, also they may exclude from patentability essentially biological processes for the production of plants and animals. So that means anything which can be grown naturally, it is not an invention. There is no inventive step involved. So no question of patentability. So that is why it can be just denied. But moving on this, there was a famous case of this onco sheep. And onco sheep, although it was a genetically modified product and it has come, but once that sheep has come, in next generation, it will go by the essentially biological processes. So what will happen in that case? So again, different jurisdictions have dealt with it differently. Canada has dealt differently, USA has dealt differently. So that's up to them to decide upon. So when again this patent is denied to essentially biological processes, it should not be denied to non-biological and microbiological processes. And now, what are the non-biological and microbiological processes for the uh, production of plants and animals? So in this case, you can say agrobacterium mediated process for the production of genetically modified plants or animals. This is one, of course. Then non-biological is, it is gene gun based process of transformation, creating transformations for generating genetically modified plants and animals. So again, there is example I just wanted to give you here. Then, however, members shall provide for the protection of plant varieties. So means whether you give a patent to uh, plants and animals, it is up to you with certain justifications for certain things, and also to essentially biological processes, but still you have to give protection to plant varieties. And if you want to give protection to plant varieties, in what form? In which standards of IPR you will use to give that protection? So in this case, it is coming like that it can be either by patents or by an effective sui generis system or by a combination of these two. So patents is, as I told you, it can be utility patent, and for US alone, it can be utility patent as well as plant patents, because plant patents are not granted anywhere else in the world. Then it can be the UPOV system of plant variety protection, and it can be any combination of these. And Indian sui generis system, it also takes care of farmers' rights simultaneously by granting protection to plant varieties. Now, because these are the subjective things on which these patents were to be granted, there was a mention of Article 65(4), and it relates to transitional arrangements. As I told you, in India, the implementation of the provisions of the TRIPS agreement started 10 years from the date of coming into force of the TRIPS agreement per se. So it was on 1/1/2005, and how it is counted upon? 1 year, it was a standard, you can say, relaxation given to all countries who can go ahead with that. And 4 additional years were given to those countries to extend product patent protection to areas of technology not so protectable in its territory on the general date of application of this agreement. So where certain, you can say, fields of patent, because patent can be granted in all fields of technology. So these were not so popular in certain countries. They can take additional 4 years to standardize all their processes and grant patent in relation to that. And 5 additional years were given that where the product patents were not given to such areas of technology for an additional patent. That product patent in India to chemicals and food substances were not given. So that is why India took this 5 years additional relaxation period, and total relaxation period came to 10 years. And from India, product patent regime came into effect from 1/1/2005. Now there is another section which has been again mentioned in the intro of this patents in TRIPS agreement, and which is Article 70.8, and it relates to protection of existing subject matter, where patent protection for pharmaceutical and agricultural chemical products as per Article 27 was not previously available. That member shall provide from the date of entry into force of WTO agreement a means by which applications for patent for such inventions can be filed. So there was a black box arrangement, means applications were filed, but these will be examined after the date when product patent regime will enter into the force in that country. And of course, exclusive marketing rights was also mentioned there, but generally it didn't come into practice because there was so much of subjectivity, and it had to be only through the regulatory clearances. Then apply TRIPS agreement criteria for patentability and priority date to these applications. First is that they will receive applications. Second is the priority date will be come into force also, and then criteria for patentability as per the TRIPS agreement will also apply. Now, the term of protection will be the net period which is left from, by subtracting the period which has already elapsed from 20 years. Suppose it has taken already 7 years, so rest of the 13 years period, this protection will be granted. They will provide patent protection from the date of grant and for remainder of the patent term, counted from filing date for 20 years, as per Article 33 of the TRIPS agreement for qualifying applications as per Separa B. Then flexibility for protection of plant varieties grant under the TRIPS agreement with examples. Here, I will just give you a narration that PVP, plant variety protection, is mandated as against patent protection for whole plants and animals and essentially biological processes for their production, which I have already told previously, but still it is like that. But PVP may be granted as patents, which can be utility patents, plant patents, or effective sui generis system, or any combination of the two. And such right may not be granted in public interest, in particular where there is threat to human, animal, or plant health, or serious prejudice to the environment, or there is issue of public order, or there is issue of morality, there is issue of ethics. So this much flexibility in just one single slide. If some of you, if you have to make assignments, so these notes can come handy, and that's why I have prepared in the simple words. Now, the Plant Patent Act 1930 of USA, because it is a unique act, that's why I have dealt it somewhat in detail. The US Plant Patent Act did not enter as a new legislation, but some clauses were incorporated in the existing Patent Act to also separately grant plant patents in addition to the utility patents. So chapter 1600 in their patent statutes book or patent act that covers plant patents. A plant patent is granted by the government to an inventor for the inventor's hires or assigns who has invented or discovered an asexually reproduced and distinct and new variety of plant other than tuber propagated plant or plant found in an uncultivated stage. So what is tuber propagated plant? Means potato was specifically excluded from the grant of plant patents in USA under this. Then any plants taken from the wild, they were also excluded from the, even some aesthetics could have been used in the wild even on a commercial scale, but these were not included for the grant of plant patents in USA under this act. Then section 1613 of this chapter says right of priority is based upon application for plant breeders' rights. Means because there are three different types through which you can protect your plant varieties, through utility patents, through plant patent, and also through UPO system plant variety protection. So right of priority across all these different farms will remain common. This is very, very important matter which has been so clearly resolved and put to practice in the US statutes. And this is pursuant to 35 USC 119F. An application for a plant patent may rely upon an application for PBR filed in a WTO member country. PBR is same as PVP. PBR is plant breeder's right. The title is on variety and title holder is the breeder, and that is why PBR. And more recently, people are fond of using PBR more over the PVP in, you can say, foreign jurisdictions. In Australia, they simply changed their law only to change their title from PVP to PBR in 1994. So this is about the priority which can run across the different forms of protection. Now this 1601 of this chapter says the act scope type of plants covered. It says that right to plant patent stems from 35 USC 161. So this is part of the general statute for utility patent. The details will emerge from there, but then it will be a part here also. As a simple stand-alone readable text for the Plant Patent Act. Then it is applicable to distinct and new varieties of asexually reproduced plants except tubers, for example, potato. Then plants capable of sexual reproduction are not excluded from consideration provided, and if they have also been asexually reproduced, like these buds, cuttings, where you can induce rooting and grow them as independent plants, there it can be applicable. That's what the mention is about. And particularly in trees, sometimes it happens that the rootstock remains different, which is more resistant or sturdy, or which can draw nutrients from deep, you can say, covers of soil. But the top, they can change by the buds or grafting, etc. And there the variety can be different. Now, there are certain case laws to justify all this, and I have specifically given 2-3 for your purpose. The term plant does not include asexual propagated plant per se. So that is where the sexual plants which can be propagated by asexual means came into picture. The second is the plant patent provisions were separated from the utility patent provisions in the Patent Act of 1952 to create this 35 USC, and which was amended in 1954. So again, so it is a standalone act also, but it's a part of the same, you can say, statute, bigger statute of the overall Patent Act. Now, this about the grant, it says in 163 that in the case of plant patent, the grant shall include the right to exclude others from asexually reproducing the plant and from using, offering for sale, or selling the plant so reproduced or any of its parts throughout the United States, or from importing the plant so reproduced or any parts thereof into the United States. Of course, in India, there was instances, and these hardly come into picture because the legal domain doesn't operate there. But the people who had transferred some of their rose varieties in South India for reproduction and then further export into other countries to the contract farmers, they were very serious and stern in the use of those cuttings. And the farmers cannot grow even one extra cutting of their own and things like that. These type of things are there because enforcement of intellectual property law is the prerogative of the title holder, not the title prerogative of government. And people who are ignorant about the implication of that law in our jurisdiction might suffer because they didn't know that it does not apply on them because they have not taken separate protection for the same in India as intellectual property. But still it happened. I mean, whatever had been out of court settlement later on is a different question. Then again, in case of grant, as provided in this statute 35 USC 161, the rights associated with a plant patent include the rights associated with a utility patent. And the right to exclude has additional terms provided in 35 USC 163. This is what has been just previously told to you. Then a plant patent issuing from an application filed after 7th June 1995 has a term which expires 20 years after the filing date of application. Means this is the date which USA chose to implement the TRIPS agreement, because they had got 1 year's transition period, but they took just 6 months, and in June 7, they uniformly made this term of protection for all intellectual property in their territory, I mean patents, for 20 years. And this was applicable to plant patent also after the filing date of the application or any earlier filing date claimed under 35 USC 120, 121 or 365C. Plant patent applications will be published pursuant to. So then again, publication criteria also came. Maybe it was not there previously. Now, dual or multiple protection to plant varieties. An asexually reproduced plant may alternatively be protected under 35 USC 101 provided the written description requirement can be satisfied. Same thing like sufficiency of disclosure is always required for patent application. An application filed under 35 USC 101 may claim the same asexually reproduced plant that is claimed under 35 USC 161 as well as plant materials and processes involving plant materials. So that means it should be the end product, also the process to produce that end product. Means if it is a bud or its cutting, or its so how it has been produced, whether some inducement like a growth regulator has been applied or anything. So all these things will be to induce the rooting in that particularly. This will be covered. Now, in this case, there are some case law cited here that in JEM Aegis Ply versus Pioneer Hybrid, the Supreme Court held that patentable subject matter under 35 U.S.C. 101 includes newly developed plants, even through plant protection is also, even though plant protection is also available under the Plant Patent Act and the Plant Variety Protection. So this is that means whether you get it protection under the plant patent or you get protection under the plant variety protection system, both protections can stand simultaneously parallel. So that means that protection will be admissible. And that depends upon you, depending upon the type of license you want to issue, that which will be more suited to your conditions to be given to licenses and all like that. The scope of coverage is not limited by the Plant Patent Act or the Plant Variety Protection Act, but each statute has different requirements and protections. That is what I wanted to say. So it is based on that you will decide that which one to opt for, but provision is there that you can protect by either of the methods. Now next we come to the Plant Patent Act of India, that is Patents Act 1970. Of course, it has been amended at least with 3 major amendments in 1999, 2002, which is to effective 2003 and 2005. And by this 2005, we had come to the product patent regime. This slide, you can say it is a redundant slide, but because both these clauses have been omitted or substituted from the present, you can say, version of the act. But I want to rediscuss this with for a purpose. Here, in the Patents Act 1970 originally, this food is not taken as a, you can say, food as a cereal or you can say pulses or grains or anything of that sort, but as a baby food or nutraceuticals. Because that was the area of processed foods where market competition is there and where you would like to get it protected to enter into the market with sound footing, to exclude others, or to, you can say, allow others only with licenses to use their product, which is a patent product. Any article of nourishment is food, and it includes any substance intended for the use of babies, invalids, or convalescents as an article of food or drink. So that is baby food and nutraceuticals. Now, similarly for medicine or drug, now it has been substituted with an altogether different class, which I am showing in the next slide, which has nothing to do with per se reading of this class. I don't know, I mean, whether they wanted to set the numbers in order, they could have done otherwise also, but I'll just share with you. They say that all medicines for internal or external use of, it is humans and animals, so I have kept animals, all substances intended to be used for or in diagnosis, treatment, mitigation or prevention of diseases in animals. Again, this is, you can say, for animals. Then all substances intended to be used for or in maintenance of public health or prevention of control of any epidemic disease among animals. Like this Persitis vaccine case I was telling you, that was related to this prevention of, you can say, annotate the shared content. What does it mean? Hello?
Yes,
Madam?
sir. Yes, sir.
There is one message that I'm seeing on the desktop that Pavan is requesting to annotate the shared content. What does that mean?
No, they are doing the annotation. Pavan by mistake, I think so. Pavan,
Okay. Then uh, all substances intended to be used for maintenance of public health. The next is insecticides, germicides, fungicides, weedicides, and all other substances intended to be used for protection or preservation of plants. Now, all these fungicide, insecticide means agrochemicals also are part of the, you can say, this medicine of or drug, which were included in the process patents were included earlier, for which in Indian jurisdiction also. Then all chemical substances which are ordinarily used as intermediates in the preparation or manufacture of any of the medicines or substances above referred to. But these classes no more exist. So that means that patent law, development of patent law is an art on the part of legislatures also. And of course, the recommendations by the experts or the technicals in that field from time to time, on the basis which all this will be done, is also there. So my next slide is not moving.
yes, sir.
My slide is not moving now. I cancelled that as you told, so I cancelled. So now it is not moving. Okay, it is coming.
Yes, sir.
So, so now the class that has been substituted against this 2L, that is medicines or drugs definition, it is has nothing to do about medicines and drugs, but about invention. And it is also an important class. And it is the definition of new invention. This has been additionally incorporated in addition to the definition of invention after 2005. And new invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. That is, the subject matter has not fallen in public domain or that it does not form part of the state of art. Of course, I mean, indirectly saying that it can relate to all these agrochemicals and all, it will be futile. But the point is that it is altogether a different class, and this has come. And there is another subclass to LA, opposition board means an opposition board constituted under the subsection 3 of section 25. Now, this section 25, if you see, it is about the, you can say, pre-grant and post-grant opposition. And whenever any opposition is made, a board is constituted. And in that case, biological diversity comes into picture and all. So indirectly, these things are related to agriculture and biodiversity, but uh, I cannot justify just on the wording of this that why this class had to be substituted with this class only. Anyway, this is just an observation sake. And because these are only definitions section, now the next section is important, that which are not inventions and relevant to agriculture field. So first is that inventions that are contrary to public order or morality or prejudicial to human, animal or plant life or health or environment. And this exception, as you have seen the TRIPS description that we have dealt under Article 27(2), that this exception was permissible and it is imperative with this article. And then there is another section 3E which says a substance obtained by a mere admixture resulting only in aggregation of properties of components thereof or a process for producing such substance. Now, of course, Kalo-inoculant case comes closer to it, but generally in agriculture, this is one PGRP, that is a plant growth promoting rhizobacteria. Some of the bacteria in the soil which will be promoting plant growth, and we generally give them as mixture of the different bacteria, different species of bacteria, different strains of bacteria. And as far as patentability is concerned, it is not patentable. So where it can be protected otherwise? If you have got a good trademark, if you have got a good brand in the market, you just protect it by this, you can say, trade secret, protection of undisclosed information. You simply don't tell, but then for the legal purposes, you have to accumulate certain data and information telling that you were conscious about it and you have tried to hide it from the public reach, so that any competitor will come to you for the license for that and things like that. So, but it is not patentable. Now, methods of agriculture and horticulture. This is a very ticklish statement. On one side, they say that it is too conservative, and when you are not allowing this protection in this area, field of invention, which is of course, as per TRIPS agreement, it should be allowable under all, except for some proper justifications. But on the other side, if we go to the sui generis IPR and our stand for the protection of farmers' rights, it's something sort of that we had in existence in 1970 Act itself. Why we are always talking of this Protection of Plant Varieties Act? For the first time it brought into for this farmers' rights also and things like that, because it is just a sort of safeguarding, or you can say safety net for the farmers to believe that their you can say petty methods or practices in agriculture and horticulture, these will not be affected by patents on the similar methods. Means otherwise, if you get patent on a method and it's a wider patent, it will cover so many processes which are obvious and but petty, and this can also be affected, and certain farmers can be forced to pay price for that, for a method which they will be following in routine otherwise without having to pay. So that means protection of farmers' rights was taken into consideration and care without having to use those words, without having to say about it, even in the Patents Act 1970 from the very beginning, and it still stands. But at the same time, on the other side of the hill, if I have to tell you, that this also doesn't mean that you cannot get protections on the methods of agriculture and horticulture which are inventions and qualify as patentable inventions, because there are essential criteria, and if those essential criteria are fulfilled, then definitely the protection can be sought. So this is a ticklish part, but you have to understand the nitty-gritties and the interpretation of the same. Now, any process for medical, surgical, curative, prophylactic, or other similar treatment of animals or plants to render them free of disease or to increase their economic value or that of their products, that is also not patentable. So it means for farm animals and poultry, for their just general nourishment and feeding and all, you need not to pay extra with patented, you can say, feed and doses of that, except for that if it is a veterinary requirement and other things, there you can will have to spend on drugs and medicines. But for their nutraceuticals and their feed, you will not have to pay for that. So now, next one is most important, that is plants in whole or in part other than microorganisms. Because they say that there is an exception to patenting plants and animals under this Article 27(3). So here microorganisms have to be patented, but you can exclude plants, and that has been virtually done here in our Patent Act after amendment, including seeds, varieties, species, and their production and propagation by essentially biological processes. And even this exception is permissible under TRIPS Article 27(3)(b). Now, a presentation of information, the tabulation or arrangement of data and other things. There is now, of course, it's a ticklish situation because after this digital indexing and digital transmission and programming, most of the decision supporting tools are digitalized. So unless until you present an information in some specific format which suits you and reinterpret it thoroughly, how your method of business can be more efficient. Because they say method of business in India is not patentable, but it's somewhere in the next amendments, one should think about it, that it should be, or if it is accepted, when it can be put into the patenting fold, so that it can also be patented. So at the moment, the mere presentation of information, or you can say tabulation or arrangement of data, it is not patentable. Now, invention, which is in effect traditional knowledge or aggregation of or duplication of known properties of traditionally known components. So this traditional knowledge basically is not for this from biodiversity point of view, which I may assume initially it was for the industrial activity, and you can say a routine knowledge is also a traditional knowledge. So that was not, you can say, or an aggregation or a duplication of known properties of traditionally known components. This was not patentable. But in the present context, when biodiversity is so important, so that means without having to change the wordings and all, these things is already, you can say, covered under the Patent Act 70, that traditional sensu, the traditional knowledge on biological diversity, as well as traditional knowledge on the technical realm, that is not patentable in India. Now, content of the specification, section 10. This particular part I have drawn from the Patent Act statutes, just for discussing in detail. that basically it's very simple thing that under Article 10, Section 10 and under Section 25 and under Section 74 or so, we'll come to that. There is mention of pre-grant opposition, post-grant opposition and revocation. So the declaration as to the source of biological material in the patent application has been made mandatory. And if that declaration has not been done, its opposition at the pre-grant stage can be considered. Its opposition at the post-grant stage till the completion of term of protection can be considered, and it can be revoked also. So every complete specification shall be accompanied by technical information on the invention, provided that if the applicant mentions a biological material in the specification which may not be described satisfactorily, and if such material is not available to the public, application shall be completed by depositing material to an international depository authority under Budapest Treaty, and by fulfilling following conditions, namely disclose the source and geographical origin of the biological material in the specification when used in an invention. And what does it cover? As far as the spirit of Indian law is concerned, is that there is a room created for the benefit sharing arrangement with the local communities involved to whom this biological material conventionally belonged to, means who are the custodians of that biological material in India. And it further says that if the applicant mentions a biological material in the specification, and if such material is not available to public, deposit material to an international depository authority fulfilling the following conditions. Fourth one, I have already mentioned, declare the source and origin of the biological material, geographical origin of the material. First is deposit the material be made not later than the date of filing patent application in India and its reference made in the specification within prescribed period, which was 3 months. Then all available characteristics of material required for it to be correctly identified or indicated are included in the specification, including name, address and depository, and date and number of deposit of material. Then access to material is available in depository only after date of application for patent in India or after a date of priority. So you have to fulfill all these conditions, and in India we have got at least one of the internationally recognized depository authority under the Budapest Treaty, which is Microbial Type Culture Collection in and Gene Bank, which is MTCC at IMTech Chandigarh. So that means for the international applicants, they can file elsewhere also and submit the certificate as per the specified here in the Act. Then opposition to the patent, pre-grant, it is 25(1), where an application for a patent has been published but a patent has not been granted. Any person may in writing represent by way of opposition to the controller against grant of patent on the ground that complete specification does not disclose or wrongly disclose source of geographical region or biological material used for the invention. That the invention so far as claimed in any claim of the complete specification is anticipated having regard to the knowledge oral or otherwise available within any local or indigenous community in India or elsewhere. It's not only that India did this amendment in their Patent Act and brought these important clauses, they also approached what WTO, uh, this council, and they wanted an amendment that the source of geographical location of the biological material used in the specifications should be made mandatory in all the, you can say, WTO member countries. So in post grant, similar clauses, same language. Okay, it's 25(2). Then revocation of power patents, it is 64. Subject to provisions contained in this act, a patent, whether granted before or after commencement of this act, may be revoked on a petition of any person interested. So it can be third party also, or of the central government on a counterclaim in a suit for infringement. Because generally what happens is they will challenge the patent when you are challenging their right to use your patented material. I mean, or there are some contract issues or in the license itself, something like that. In a suit of infringement or of the patent by the High Court on any of the following grounds: that the specific completion does not disclose or wrongly disclose, same thing; that the invention so far claimed in any claim of complete specification was anticipated. So anticipation of TK or indigenous community, same thing. Now, there are two enforcement cases which I specifically brought for you for discussion. One was this Monsanto's genetically modified BT cotton patent enforcement case. And here what had happened is that on 28th March 2017, a single judge of Delhi High Court had dismissed Monsanto's patent enforcement plea against Navzidu Seed that it was using technology patented by Monsanto even after termination of license. So Monsanto was directed to continue with its obligations under sub-license agreement. Then further in okay. But what happened that the Supreme Court, they restored Monsanto's patent claim on this GM-BT cotton until its validity is decided by the Delhi High Court. Again, single judge. Monsanto would continue to enforce its patent till then. So that was one part of it. Then second part of it is that Supreme Court, with its same ruling, also set aside another, you can say, decision by a division bench of Delhi High Court, which had held in 2nd of May 2018 that plant varieties and seeds cannot be patented under Indian law. So this is the point that after losing this 2017 case, Monsanto and their Indian partner Mahiko, they again approached the High Court, and but they didn't get any further relief, and they were told that plant varieties and seeds cannot be patented in India. So once their patent has been invalidated, they cannot enforce the license. Now it has come in the public domain, and they must make this available to the other party, that is Navzidu Seed, for general commercial use. Then this cannot be patented under Indian law, and royalties on GM technology would be decided by a specified agency. Now, whether you want to charge this trade fee like a very high or very low, that was not the court to decide. But then in agriculture ministry, there should be a specialized agency who will decide on that. And what is the noting of the code in that? It is important in Supreme Court in deciding on 8th January 2019 is that we are satisfied that the division bench ought not to have disposed of the suit in a summary manner by relying on documents only extracted from the public domain and not even filed as exhibits in the suit, much less examination of expert witnesses in the facts of the present case. So now this is important. Merely that I am seeking justice saying is not sufficient. I should also produce evidences that I am aggrieved. That is about seeking justice. And similarly, giving justice, merely that reading from here or there and taking a decision there in the table itself without making it documents on record is also not justice. So this is what the latter part Supreme Court noted, that even though they have given that decision that plant varieties and seeds cannot be patented under Indian law, but then there was counter arguments by them, which by the you can say Monsanto and Myco, which have not been brought on record, and only public domain material has been used here and there to decide on the case, and mostly too hurriedly. So they should relook into the entire thing and examine the patentability issue also. So resolution on of price fixation of trait value of protected variety. So what happened? This specialized authority was the Protection of Plant Varieties and Farmers' Right Authority, which is, you can say, the implementing agency for the PPVFR Act in India, that who took mid-course correction measures concerning the price fixation issue. So they came out with an order under Section 7 and 28 of the Act, delinking trait value fixation of unprotected varieties, also varieties whose term of protection has expired, from that of the protected variety. So that's January 2019, there is a public notice by the authority, which also set procedures for sales and sale price fixation under Section 28, that is plant breeders' rights, for all registered varieties during their term of protection. And then under sections 64, which is about infringement, and 92, which is overriding effect of the Act, also invoked in the notice to enforce newly elaborated provisions of the plant breeders' rights. So that means they say that now, since under section 92, this act has got overriding effect. So it is overriding over the Patents Act. And whatever decision they are taking, that will be legally binding. Second case is about PepsiCo's protected potato variety enforcement case. This was second major recent issue under PPVFR Act in the recent times, next only to BT cotton price fixation of trait value case. And it threatens the long-standing market decides rule of the business realm. And it keeps at bay the exclusive marketing rights privilege available under the IPR law. The case involved use of seed of PepsiCo's protected potato variety, accessed for contract seed production by some farmers and as farm saved seed, and making it available to other farmers who then use the same for commercial activity. Now, details of variety protection particulars are given in the next slide. I'll come to that. And PepsiCo, considering this to be a sensitive relationship issue involving farmers, ultimately refrained from pursuing it as legal dispute. So it was just withdrawn from the court. And this is what happened, but it was a very important case which was discussed for the long time. But these are the details of that variety, FC5 potato, which is for this Pepsi's chips making. And Then its registration number is, it was registered in 2016 as extant variety, and its denomination registered was FL 2027 for potato, and applicant was of course same PepsiCo, and certificate was issued on 2016, and it would have been valid up to 2031, but still under farmers' rights, because you have taken the seed on the contract basis. You don't have automatically right on that to sell it to other for commercial activity. You can give only for sustenance purpose. This is something legal but sensitive also, because in mob mentality, the meaning altogether changes. So I will not go into the details, but it is understood. But PepsiCo, they simply withdrew from it and they didn't pursue the case. Now, some slides for miscellaneous academic address. This is the slide which is telling you that agriculture for patenting is a vast area. Primary products, industrial derivatives, and agricultural inputs. These are the three basic areas and which you can talk of patents in agriculture, and of course plant variety protection also. And I just have listed it for your purpose. And if Dr. wants, I will share these slides with her also. And these are some of the noteworthy disruptive technologies emerged in agriculture in recent time. I was national coordinator for one of the consortium-based projects funded by World Bank, that is NAIP, National Agriculture Innovation Project. And some of the technologies we generated in agri-biotechnology, in nanotechnology, and sensors, also some decision support system. And I have added a column for drones also, because it is also an important technology where there is a vast scope of dealing with the patents. So for those of you who want to be experts in patents and then in agriculture, these are the areas which you can explore. This is just interpretation on patentability in agriculture search, which is common to everything, that essential requirements, novelty, non-obviousness, and industrial applicability, and considerations of exceptions and exclusions. It should not be discovery, it has to be invention. Then it doesn't have to be essentially biological process. Somewhere, some mediation or some, you can say, industrial mediation has to be there. For that purpose, here a patent can be granted. Then exclusions as per the TRIPS Article 27.2 on the grounds of public order, mortality, and protection of human, animal, plant health or life, and avoid serious prejudice to environment stand. And then you have to make the patent document by presenting the specifications and claims. Anything that is not claimed in the claims part, it is not claimable for the purpose of infringement. You cannot say that I had given this you can say mention in the specifications of my patent document. If it is a part of the claim only, then the infringement issue arises. And then, of course, sufficiency of disclosure, in which case, particularly this disclosure with regard to the biological material used in the invention and its source and area of origin is important. Comparing patent and plant variety protection, the subject matter of protection is invention and plant variety, whereas the invention is defined by claims. The plant variety is a protected variety propagated by essentially biological processes, and it is a wholesome product which has to be commercialized. Then criteria in case of patent is novelty, non-obviousness, and industrial applicability, whereas in case of plant breeders' right or plant variety protection is novelty, distinctiveness, uniformity, stability, and distinct nomenclature. Because the name of the variety, once you give in the register of protection of plant variety, it has to survive even after the term of protection. So lifelong, and it has to be unique and novel. The search criteria have to be different accordingly. So then last slide is about this Indian PPVFR Act. Some of the unique sui generis provisions of the Protection of Plant Varieties and Farmers' Rights Act, and which talks of protection of extant varieties, means these varieties were existing in the commercial domain, although not protected previously. So these were allowed to be protected under the Act for certain period of time, and that there are specifications and there are prescribed methods and procedures for that. Then farmers' rights, there is a full-fledged chapter. No to GURT. GURT is genetic use restriction technology. Terminator technology means you cannot put any biological tool or you can say taboo in such a way that the next generation will not come into fruiting and seeding. So you have to give an affidavit of a dimension of rupees 100 telling for each and every application that you file before the PVP authority. And benefit sharing, there is a full-fledged provision and compensation for underperformance. So if the protected variety does not perform to certain given description, so then compensation can be claimed by the farmers for that. But it is not a compensation that they can claim only for this vagaries of nature and all. It is only with respect to this act and with respect to the permissible traits, or you can say permissible characteristics of the plants on which this protection has been given specifically to that variety. Then claims for community rights. These, I mean, those communities who are using some traditional seed or material, and their seed and material that is either used or potentially usable for the development of new varieties, they can claim certain rights and which can be granted under this act. So I will not speak, but will wait for your questions now.
Any questions are there? Participants can raise it. Participants can unmute and they can raise the question if anything is there. If not, they can put it in the chat box.
If not students and faculty also, if they want questions, you can ask.
Sir, I have one doubt, sir.
Yes.
Sir, in the PVP Act, what we can see is that there is a overlapping in the definition of an extant variety and the farmer's variety.
Okay.
If you see the definition of an extant variety, it says that even the farmer's variety is covered under the extant variety.
Surely.
And the requirement for the extant variety is DUS. It should
Yes.
be distinctive uniformity and stability. But in the
Right.
case of a farmer's variety, they don't have
Hmm.
to comply with the standard. So
Okay.
if a farmer register it as an extant variety, they have to comply the standard of an extant variety.
Yes.
But this leeways are being given for the farmer's variety. Isn't
Definitely.
this overlapping is defeating the purpose of the law?
Technically speaking, yes. But the spirit of law, if you have to, you can say unravel, then maybe it's not, because what is happening is that I don't know how to open this. I'm not able to even go to the screen back. But I am visible there, na?
Yes, sir, you're visible.
Okay, okay, no, because I will not be able to see your side. No
Okay.
issue. Now,
Hmm.
let me tell you that for extant varieties, there are three categories, not only two. One is the varieties which were previously registered under the Seed Act Section 5. And
Fine.
what are those varieties? The varieties which got the regulatory clearance for sale of those varieties or seeds in the market, with for the assurance that the quality of the seed in the market will be maintained.
Hmm.
That is one category of extant varieties, because it is a legal transaction, and it's very clear that these were legally registered previously somewhere. Second is the varieties having common knowledge. Means these varieties are the category which might have been registered under the Seed Act, but then their term has expired. That can be one thing, or they have not been registered at all. But people growing those varieties in the region, or companies selling the seed of that variety, obviously have got sufficient, you can say, data and proof backing that these varieties were existing, and these are also the category of extant variety. And third is the varieties which the farmers conventionally were propagating in their own uh, fields or backyards, and those varieties were perpetuated as such. Now, as far as the DUS testing part is concerned, it is for the purpose of defining the distinctiveness of one variety from the other. So, unless until I am able to ascertain that this particular variety is different than its closest rival, I will not be able to give any judgment on that. And that is the reason the DUS tests are performed. The distinctiveness, uniformity is that when it is being propagated from generation to generation, within the limits of the variability that is expected to a technical person knowledgeable in the field, this variety is performing similarly. Means sometimes it can be, height can be taller or smaller, or some leaves can be shortened or anything, but they can judge that this variety is the same as the variety which was grown in the previous year, or grown at a different location. And third is stability. So that means from year to year, it is not giving a statistically significant change in its overall attribute, overall expression as a crop. So these are the criteria. So as far as no farmers varieties recognizing as extant variety is concerned, it is the goodwill of the farmers. And since we, under the sui generis system, are already giving relaxation to farmers on many other counts, not only merely differentiating the, you can say, state of existence of their varieties. So it is, farmer is the best judge to tell that, well, this red rice which that he is growing in this village or cluster of these many villages in this zone is different from the red rice that you will get from another state or from another region. So still, for the purpose of having a common understanding in the perception of farmers and the experts who have been dealing with the farmers from the day one of their professional jobs, so they will be able to judge that whether farmers were correct or not in giving that statement. So that is why amicus curiae status is required. friends of the court will also be involved in such circumstances. So we are not giving right over any variety which is not having any commercial value. Suppose a farmer is growing a variety which is available in only 4 or 5 plots in that village. We will not encourage them to get protection for that variety, but we will definitely encourage them to increase propagation of that variety in case they feel that it has got certain desirable characters, and to come to a level that where it is commercially acceptable. If it is scaled up to that level where it is commercially acceptable, only then we will take it to the level of getting it protected. And getting protection means at least it's a sort of awareness creation plus sensitization, so that they know what is the area which is being tagged off and how they have to prepare themselves for the same. Because now farmers can get their varieties protected not only as extant variety but also as new variety. And unless and until they know the
Yes, sir.
nitty-gritties
One
of
more
it,
doubt, sir. When
yes,
you're saying that the farmer can register the variety as a new variety,
yes,
again the farmers has to comply with the DUSN standard.
there they have to
And that
comply with
too,
on
and
full
that,
scale.
yes, sir,
There,
yeah, full scale. That too, they
yes,
have to give the genotype feature of it,
yes,
not the phenotype. I
yes.
think if the law will be more what you call farmer oriented, if the law would have incorporated both the phenotype and the genotype feature, I
Mhm.
think the farmers who are traditionally breeding the variety and they are conserving and preserving, they use a traditional breeding method to develop the new variety. And for them, the
See,
genotype
one thing,
feature
one
would be
thing,
a
one thing.
difficult task.
Let me. No, I have got your question, but I have an answer which doesn't have any shortcut except for just a long explanation. But to cut short, still is that farmers are traditionally holding that material in semi-primitive to primitive or to semi-advanced stages rather than a commercial variety level stages of that variety. That is
Okay.
why the extant varieties don't belong to farmers. They need certain different consideration than the varieties which after the coming of the law into force, they claim that they have bred and they want protection on that. I mean, after the law has come into force and then they want protection and they claim that they have bred that variety, so it is deemed necessary that they come with some participatory approach,
Yes.
whether their NGO has got some breeder involved or an entomologist or pathologist or agronomist involved, someone
Hmm.
who is clear about the variety development, or I mean, whatever it is. So there they cannot just shirk and say that it is their conventional material. It's a newly bred material and law is already in force. So I think here I will be able to give answer to much of your inquisitiveness, if not query, that the material which has been uh,
Develop.
treated as extant
Hmm.
is the material which was in state present as such, which was in whatever form they were using it. But now the next material that they will be developing, they will be evolving and developing, will be the one where they have to compete. And if they have to compete, they have to fulfill all the criteria. So whether it is NGO or any government agency or any university or any R&D lab, so they have to go in for
That's it.
participatory, or sometimes farmers themselves, they are educated ones who
Hmm.
can go in for those things. Yes.
Okay. And then in the PepsiCo case, they would have taken the plea of a farmer's right.
No, they took the plea of all that only, but it
It
got
came out of court settlement.
See, it was not even out of court settlement. It was a political push that
Uh,
things were just knocked and
Okay,
Yeah.
okay.
Silent.
I would have felt that rather than that, they would have contested the case and they would have taken the plea of a farmer's right, stating that they can save, exchange, and share it among themselves.
Basically,
Yeah.
the difference between a developed and developing state
Yes,
or mindset explains everything. So we could not have expected many of the theoretical things to prevail when it's a developing state.
yes,
So it is in that context that Pepsi was, you can say, clever enough not to indulge into or involve themselves beyond a limit. Because in case of Monsanto, it is a clear-cut case of so much huge benefit their licensees have already taken, and they were denying him the royalty.
yes.
Irrespective of what was the royalty rate, that's a separate thing. But the question, legal side is that denying the royalty and what Supreme Court decided on it. Because again, it will go to competition commission. Again, it will go to other procedures before they will settle in any revised rate. Because in any case, the wastage of money that he has done into fighting in the courts, that he will recover only by giving lesser amount. That's what we did.
That's true, sir. That's true. I feel that the Delhi High Court has done a good job in the Monsanto case. If you look from
Done,
that, the
done a
Delhi High
good
Court,
job.
yeah,
So
they
no,
have done it
point is
from
point is about interpretation. See,
interpretation. Yes,
basically,
sir. Yes,
basically, point is about interpretation, and at that time, the IP uh, side of Delhi High Court was not so strong.
that's
Now,
true.
of course, you have got so many
Hmm.
judges who are into IP area, and it's not only single judge IP
And
expert.
maybe the coming generation judges may do
Yes,
far better.
yes, yes,
Yes.
yes,
Yeah.
definitely.
Any other queries? Any participants?
Sir, I got a question.
Yeah, please.
For the, in recently there were news about this Covishield vaccine, uh,
Okay,
which is causing a heart attack in the middle-aged group. That is
okay.
patented, right, sir? So, if is it, will there be any action that will be taken against that one if it is, since it is not scientifically proved against the manufacturer of the Covishield?
Mm, very first thing in this case is that if you see the history of vaccines, no vaccines were, you can say, released for public use in such a hurry. And it was a question of a compromise between this and that. And in that case, the number of lives saved surpasses, of course, even if one life could not be saved is very, you can say, painful, but still, when you have given them clearance only as a test case, you have not given them clearance for the open commercial utilization, right? So you have given them clearance for manufacturing and use through agencies only. And that is why it's a sensitive issue. I think you will be able to draw inferences yourself than we trying to find out answers out of it. Because basically what happens is the most difficult part even in law is that setting the two panes of the, uh, you can say, balance in the same plane, same level. The, you can say, eyes are blindfolded and the pains are up and down, and still judgment has to be given. How much taxing it is for a mortal, for a human being to have able been able to decide on that with all that of taxing on the minds. So it is, I mean, an exceptional circumstances that we have seen so much of safeguarding of the humans in this COVID era than of because what you have told, it is not wrong, and it is not that it was never told to anyone. Everyone was told that there could be side effects, and these side effects will not prevail for everyone. I mean, you needed to have the general resilience also. You needed to have a common health level, minimal health level of the bodies on which it has been given. So, you see, what has happened in the COVID era is a loss that we were not able to get recognized the resilience building Ayurvedic system of medicine because people were again misusing it. Someone is taking too much of kada. Earlier, they are not taking even one kada sip a week, and here every day they will be taking 7 glasses. So that is so much of the thing of human behavior and attitudes and habits and mindsets and the things. But you are right that side effects were there, and side effects were there for quite a few. And then, of course, it is coverable through alternate means like insurance and other. And if God is your side, then recoveries also are possible. It's not that recoveries are not possible. I mean, this is all about agriculture. Agriculture is the source of perpetual creation on which civilization depends. Anything that comes out of it, it is creation. It's a, you can say, coexistence of so many organisms at the same time, which we are not able to see with our own eye. The microflora in the soil, the microflora involved as friendly microflora on the plant's body itself, the microflora attached with the pollinators and others. So all this, you can say, ecosystem is set. So it's much beyond law. You can say these are not the things. It's you can say natural justice principle only. In the natural justice principle, you cannot rule out accidents, but you can hope for the best solutions somehow. This is what I can say.
But another question, sir.
Yes, please.
Um, uh, there was a rice variety called the golden rice that was in news
Yes, yes,
some few
yes,
decades,
yes, yes,
1 decade back.
yes.
So
And
they have got
what they did is that they got patents for different steps in the processes of developing that technology, and they could not produce independently, the big companies, because some of the patents belong to other company. They pooled the patents so that they can use and make a product. But it doesn't mean that it will come as a successful crop at its own. Maybe many of them were experimenting, and maybe still many of them will be experimenting only. There was a cross between wheat and rye. Rye crop is a, you can say, cereal come fodder crop in Europe, and wheat, and the cross of that made triticale. And they said that they will be coming with a new crop, and this will be a solution to many things. So it was there. So many extensive trials were done, international nurseries and trials were done, but it is not necessary that everything will be successful overnight. But what is your specific question beyond what I have interpreted?
so we have a lot of rice varieties which are in the verge of extinction, sir.
Okay.
And basically food depends upon the land where we live. So
Yes.
imposing something strange variety in a different land, won't it cause any long-term effect? Because it's against the principle of nature.
See, I was in Arunachal for 6 years, and there is one plateau at 5,000 feet elevation, which is called Zero Valley or Apatani Plateau. And there is some 4,000 acres vast land which is maintained by tribals for paddy cum fish culture. They grow rice there and they grow fish inside the living rice plants, and they will survive on fish till the rice comes. And they have so meticulously developed sub varieties out of those that some of the fields are in the hillside, some of the fields are purely in the valley side, and then in the middle of it there is a you can say small outlet of water which is called Kale River, where water flows at the rate of 60 kilometer per hour, and this is protected by the wild grasses on both sides, so that there is no you can say losing of size on that. And what I wanted to tell about varieties of that area was that these are 9 months duration varieties, 270 days. I tried to grow those varieties in Pasighat area near the Siang River, and which was, you can say, a hot area compared to this valley, and about 800 feet elevation as compared to 5,000 feet. Of course, these rices could grow there in 180 days to full seed setting and everything. But obviously, their morphology, the vegetative part was okay, but seed yield was lesser. And if you take any of the improved varieties to that Apatani plateau, including the most popular Eri red varieties like IR 36 and IR 64, etc., none of these varieties these will adapt well in that area. So there is local specific adaptability also. This is a natural phenomenon known to the persons knowledgeable in this area. So if you say that extinction will come, the extinction will come due to many other reasons also, because the time when these were originally cultivated was never subjected to so many agrochemicals and so much of chelation, chelation, chelation of those you can say agrochemicals in the sub zone soil zone level. So is there. So poisoning is happening and many things are happening. So extinction can come due to that reason also. But that's why this gene bank are developed for that purpose. Now our National Gene Bank at NBPJ New Delhi at minus 20 degrees centigrade, it conserves about 4,90,000 seed samples of different crops. And rice has got the maximum number. So it's, you can say, notionally speaking, the representative diversity is hoped to be collected and preserved for 100 years or for the use by posterity and things like that. So it's just a part of education and research and training and things like that. When it's nothing to do with law except for the natural law principles. In the ecosystem, it's not only for the purpose of helping each other. Natural ecosystems kill each other also. But here in case of plants, the alien species, the foreign introduced weeds, these can kill your crops. There also extinction can happen for the, you can say, native crops or native varieties. so many things. But we are, for the day, we were rather talking of only the industrial applicability or the industrial side of the plant varieties, or you can say innovations in agriculture which can be protected by patents and plant varieties, etc. And on which there are rules of the game, on which those rules of the game are sometimes understood, sometimes lesser understood. So we have to come to a level where this can be done. And I think education is the medium through which you are learning. You are in the learning processes. You will make your own assignment, means you will be learning much more than what has been dealt today.
So,
Any other questions? So we can wind up the technical session, Kanmani.
Anything in the chat box, if you can read from your end, because I am not able to see all this in the screen. Na?
So nothing is there. No questions are
It's
there.
okay. Okay, no issue then. Yes.
Uh,
In any case, if anyone has got any question, I have given my this email address. You can send to ma'am or to me, and we can give you the answers.
Do it, sir.
Okay.
Shall I start, ma'am?
Yes, ma. Yes.
Good afternoon, all. I'm Kanmani from Jamnagar Dr. Ambedkar Law University doing LLM in Intellectual Property Law. On behalf of our university, I take this opportunity to propose this vote of thanks to who are all contributed to this webinar on the topic of patenting in agriculture's academic and legal perspectives organized by our institutes. And at this outset, I thank our chief guest and our resource persons, Dr. Sudhir Kochhar, sir. We are really enlightened with your presence and knowledge, sir. And we have learned a lot about the histories and then protections of plant varieties in US and then India and then under the TRIPS agreement. And also a special thanks to our head of our department, Dr. Loki George ma'am, and our professor Sunil Gladson, sir, and then Aarti ma'am, Brinda ma'am, and also Jeffrey, sir. So, and I also thanks to the students who attended the meeting and also the student coordinator who supported throughout the meeting in making this webinar a great successful event. And once again, thank you, sir.
Thank you. Thank you, ma'am.
Thank you, sir. Thank you, sir.
So nice of you.
Good to
Thank you
meet
very
you,
much.
sir.
Okay, thank you.
Thank you, sir. Feedback form is posted in the chat box. Participants, kindly fill the form and submit it.
Okay, thank you again, madam. Shall I
Thank you,
close?
sir. Yes, sir. Yes, sir.
So you will send me the recorded one, na?
Yes, sir. I'll do it. I'll do it on Monday.
Thank you.
Okay.
Thank you. No issue. No issue. Take it.
Okay. Okay.
Thank
Thank
you.
you, sir. Okay. Darwin is there? Aarti? Yes, Aarti.
Yes, madam.
Aarti, Darwin இல்லையான்னு நினைக்கிறேன்.
Okay, madam. நான் phone பண்ணி சொல்லிடுறேன், madam.
Okay, or we can close it, huh?
Yes, madam. We can close it. You are also co-host, madam. So you can close it,
We can
madam.
close it, huh?
Yes,
Okay,
madam.
I'm
Okay.
closing it.
Okay, madam.
Do you want to leave the meeting there, கேக்குறேன்.
Yeah, அதுக்கப்புறம் close the stop the meeting கேக்குமே, madam. Recording
இல்ல.
stop பண்ணிட்டீங்களா?
Recording is going on still.
First you stop the recording, madam. Then we can end the meeting. There will be option.
Record.